Good evening, this is John Milburn for Laws 11059 Statutory Interpretation, and this is week 11 of Term 3, 2018. Tonight we're dealing with issues to do with feedback in relation to the second assessment, your toolkit, the way that you applied the toolkit in your second assessment to the hypothetical scenario, and we're looking forward to the examination next week, looking at some techniques that might assist you. Next week, we'll do an overview of the entire unit. So essentially, we have just about dealt with new material in this unit. So that's the good news. Now, in terms of the second assessment, the work that I received overall was very good. I'm very happy with the way in which people thought creatively about their toolkit and then importantly applied the toolkit in a meaningful way. Given the nature of the exercise, there was certainly no one right answer. If you scored an overall mark of 15 out of 20 or more, congratulations, that puts you in the distinction or even high distinction category. So they're excellent results and you should be very pleased with that. If you achieved a result of 13 or 14 out of 20, that puts you in a credit category. And of course, if you received a result of 10 to 12, that's in the pass category. So nothing at all wrong with those marks. The main objective is to pass the assessment, pass the unit, and at the same time, share information to some degree and learn into the future. Looking at the workshop or the toolkit, as I indicated, many people had different approaches. What I've done is just at random selected two of the better papers. I won't disclose who the authors are. I'm not going to show the information, but I'm just going to go through some of the information that was provided in that paperwork to share with you. And thank you to the authors for this, and I hope you don't mind. So again, it will be anonymous at this stage. In terms of your toolkit, the comment that I've made, I guess fairly consistently through the unit, is that this is a personalised document for you. It's important that I understood the logic behind what you were doing, that technically your information was correct, and that you otherwise complied with the requirements of the rubric and presented something that was in a professional format. But in terms of format, the general rule book, if I can use that term, for the submission of an assessment in law was to some degree out the window, because I wanted you to create something that works for you in a practical sense. So the main emphasis of the toolkit was to provide something that you can actually use. Those of you watching the session now or attending live, and thank you all, we've got good numbers as we have been this year doing so, or if you're watching a recorded session, I'm going to ask you to reflect on this, and those of you that are joining me live, you can answer this. It's just a yes or no. And the question is, honestly speaking, when it came to answering the second question, that is the hypothetical exercise, did you actually use your toolkit and did you follow the steps that you'd written for yourself in terms of how to answer a statutory interpretation question? So just for those of you joining, yes or no, I'd appreciate that. Okay, we're getting overwhelmingly answers of yes. Well, that's good to hear, and I hope that they're honest answers, and I'm sure that they are. And some said maybe, maybe not so much. So if you're in that category where you found it actually useful, then you've created a document that works for you. It may not work for somebody else. They may not entirely follow your logic or your approach, or really like the sources, either primary sources or secondary sources that you've selected. If your answer was, I used it a bit, or I didn't use it at all, then what I'm going to ask you to do, and there's no marks for this, it's not a regrade of the assessment, is to go back and honestly change what you've got. You don't have to submit it to me, but create something that actually does work for you, that you can use in a real sense. Some people, in presenting their assessment, their toolkit, provided excellent flowcharts. Now, they may be flowcharts that are designed around the flowchart produced by Michelle Sanson in her textbook, or, as is the case in many instances, a flowchart that was created themselves by thinking about the materials that we've talked about during this unit and putting it into a format that works for them. Also, there's no magic in 5 steps. In fact, to some degree, that was a furphy. That was just something I thought of. 5 steps. Very arbitrary. Now that we're past the assessment, if you don't like 5 steps and you want to go with 9, go with 9. In other words, I'm asking you to change your document so that it works for you, not just for the exam next week, but also for any law exam or assessment that you need to undertake, because there are probably 2 things that you'll need to think about when answering any legal question, whether it's contract law, constitutional law, torts law, whatever it is. And they are, number 1, interpreting statutes, which means that you will be using your statutory interpretation skills to answer a problem that might be constitutionally based. So don't be afraid to introduce some commentary about Section 15AA, or cite something from Project Blue Sky, or refer to the context or intent, or make reference to and extract material from a second reading speech, even though you're not doing statutory interpretation. It's really important, because we're teaching you this and emphasising it in first year for a reason. It's a foundation subject. It's a foundation unit. That means it flows over. It's not a discrete area of practice that you're learning now. Make sure that you use it. If you've watched my video and I talk about level 3 preparation, what I'm really asking you to do now is level 4, and that is prepare something that you can use for yourself in the rest of your law degree. Now, you won't use it exclusively, because you won't have any further units beyond this that are purely in relation to applying statutory interpretation principles, but it will crop up in practically every legal subject that you use. So please use it. So adapt your toolkit and make sure it's useful in a real sense. Oh, and Tanya says, I was speaking with a QC recently, asked if we'd talked about Project Blue Sky, and said it was a very important case in lots of areas. So excellent. I'm very pleased that. So there is a real practical aspect to this. Now, I said that there are 2 things that you need to consider in any legal question you might answer. One is statutory interpretation, and the second is in relation to ethics. Those of you that are doing Introduction to Law with me at the moment would be aware that that's also something that I stress. So when you're answering any legal question, make sure that you at least think about whether there are any ethical or practice issues that might be relevant to answering the question. It may not be called upon directly, but it should always be there, and you should never shy away from introducing that material into a general answer. So if you find it appropriate to quote something from the Australian Solicitors Conduct Rules, or something from the Legal Profession Act, or something from a practice direction, then I encourage you to do so, even though it may not necessarily be asked for in your assessment. I will put a rider on these things, and that is that the comments that I make to you now are of a general nature. Please be guided by your unit coordinator in a specific unit, because that unit coordinator may have very particular requirements. Although I think it unlikely that the unit coordinator would say to you, in answering this question, I specifically do not want you to think about statutory interpretation, and or I do not want you to think about ethical or practice issues. If you have any doubts, then you can always ask the question of your unit coordinator at the time. Now, does that all make sense? All right. So if you've given me a big yes in answer of the first question, great, you're on the right track. You probably don't need to change much. If the answer was, I can do better, I can change it, now I'm not constrained, do that. All right, so what did we see as a common feature of some of the better answers, at least from my perspective? So bear in mind, there's no one right answer. What I was looking for is something that I thought people could actually use in practice, something that was practical. So some of and I've got two model answers, well, two answers up on my screen, which I won't share with you, but where students performed well. So one of them said, look, my stage one is to consider the problem. So that was stage one, a statutory interpretation. And under the heading of the problem, there was issues about considering the salient features around statutory interpretation, consider the material facts that might be incidental to the statutory interpretation problem, and then think, and this was lateral thinking, think about deficiencies in drafting of the provisions that might cause the words to be ambiguous or might lead to a conclusion about an obvious omission in the drafting. So they're some of the things that that student raised. Another student said, my first step is the legislation. Looking carefully at the legislation and asking the question, does it apply in the current circumstances? Now, you might say, well, that's all pretty basic, and it is to some degree. But you can go further and say, well, here's where I sourced the legislation. And whilst you wouldn't normally include hyperlinks in a law assignment, being a toolkit personalised, I encouraged you during unit to actually do that. So add your hyperlinks in, make it easy for yourself, make it something that you can use when you're under pressure. And of course, you would need invariably to refer to the Acts Interpretation Act at an early stage somewhere in the process so that you're considering the legislation in conjunction with the Acts Interpretation Act. Now back to the first model answer or good answer, stage two was said to be the legislation. So similar considerations dealt with as stage two in the first paper that were dealt with in stage one in the second paper that I'm referring to. The second paper, the second step was context and purpose. Now, given there were only 5 steps, there was invariably going to be some sort of doubling up. So you could arguably separate these things, but I think that context and purpose work so closely in alignment that it's useful to put them together. And I think you would almost invariably have to refer to Project Blue Sky at an early stage. And most of the better answers did that. Again, you didn't have to. If you didn't believe that Project Blue Sky was necessary in your interpretation process, then that's fine, but I think it probably is. Very commonly, of course, we had reference to the CIC insurance case and the Bankstown Football Club. So that was step 2 for the first paper. Second step in the second paper was context and purpose. So very similar. Number 3 was, in the first paper, was context and intent. And in step 3 in the second paper was intention and interpretation. Again, most of the papers these included referred to not only pieces of legislation, such as Section 15AA or other necessary pieces of legislation, but also referred to leading cases. Mills and Meeking was a regular case referred to by students. And when I say referred to, I mean extract the vital parts, the parts that you actually need. Now, in some cases, students, it seemed to me, filled the paperwork with things that they might think of if they were writing an essay. And some of the papers that were a little more ordinary looked to me like essays, explaining the situation. What I really wanted something is where you can use information in a quick sense, in a practical sense. So if you're in that category where your work toolkit didn't really help you in a practical sense, have a look to see if what you've written is more like an essay rather than for want of a better term, some checklists and some signposts and some flowcharts. Coming back to some of the better answers, in the first paper, the fourth stage was intrinsic materials. The fourth stage in the other paper was also intrinsic materials, and stage 5 in both was extrinsic materials. So that's a pretty logical way of looking at things. Your paper may have had something similar to that, but if you look at your paper and it doesn't include relevant quotes, if it doesn't include hyperlinks, if it doesn't refer to appropriate secondary sources, such as Michelle Sanson, if it's not laid out in a way that you can work through quickly, in other words, if it's long prose, then you probably have some work to do in improving it. I hope that that provides some degree of further feedback in relation to the toolkit. Now, in terms of answering the question, the first thing that you need to understand is, what actually am I looking for? In this instance, I think the question called upon you to provide an advice. So you weren't providing an essay, you're providing an advice, and you're tailoring it to your audience. So again, when you're answering any legal question, make sure that you carefully understand what it is that the examiner asks you to do and provide a response to that. Always, of course, you need to consider issues to do with presentation, referencing, make sure that you follow the Australian Guide to Legal Citation, footnote referencing, and presentation, all the basics, legislation and case laws in italics. Make sure you paginate your document, all of those things. So when you're providing an advice to a client, again, be careful not to fall into the trap, as some did, of writing as if it was an essay. An essay is a very different thing to an advice. What do you think the clients want more than anything else in an advice? You can use the chat facility. What do you think the most important thing for a client? Okay, some good answers coming in here. Tanya says options. That's good. William says know what to do. Yep. Tuna says solution. Tim also says what to do. And Amy Lee says clear thoughts and guidance. Yes, exact. All of those things. So clarity of thought, precision in your language, positive communication, writing in an active voice, quite often in short sentences, providing a clear statement of options and providing solution to the problems, or at least an advice as to the appropriate solution, is important. So if you look again at your the second part of your answer, and you believe that it does look more like an essay rather than an advice with that clarity of thought and focus in wording, it probably is something that you could improve upon in future if ever asked to give an advice. So those students who were in the pass category or lower credit category were probably writing more as an essay rather than a straightforward direct advice, and always provide some option or options, better still, and provide a clear statement, make a call. Your call may be wrong if the matter was tested in a court, but that doesn't matter as much as your failure to make a call. So you've got to say, this is what I believe. This is my advice to you. So it puts the pressure on you. Question is, do we have a CQU memorandum advice format? No, we don't. That's a really good question. There isn't one in practice. So people have different ways of setting things out. Look at the sample document that I've prepared to get some idea of general formatting. Usually an advice will have a cover sheet. That's not part of the sample document, but very easily accessed through the Word program. And quite often the feedback that I provide you is I use a cover sheet quite often. So quite often I'll have a cover sheet. If the advice is lengthy, it's sometimes a good idea to include a contents. Make sure that your headings are that work that way. The only thing that I'd say is that don't include a bibliography or reference, because that's not part of the Australian Guide to Legal Citations. So when you're providing an advice for the purpose of assessment, it may change slightly from an advice that would be provided in the sense that there's no reference or bibliography. But having said that, typically we don't include those things in a legal advice anyway. So what you produce in accordance with the AGLC will be fairly consistent with what's in practice. But no, Chenna, there's no prescribed form. If anyone has come up with a skeleton of an advice or a skeleton of a way in which they drop in their information, then please feel free to share that, and I'm sure that we'd all be grateful for that. So, but you can use the feedback document, the sample document I've got on the website just as well. All right, so there's some of the common features of the better answers that I saw, those that were in that distinction or high distinction category. Are there any further questions in relation to the second? Oh yes, and Tuna says, like the feedback document. Now, were there any further questions or comments in relation to the second assessment? All right, let's now have a look at the take-home paper. What I would encourage you to do is look at the paper that is on the website from last year. I think it's appropriate to always consider the rubric. And if you look at the rubric now, if you've got that with you, or you can access it, if you're looking at this as a recorded session, please do so. Because the rubric that was applied last year is the sort of rubric that you can expect to see this time. What do we really want? So from a statutory interpretation perspective, if you've got an answer, if you're answering a problem, you need to identify the core facts. You need to identify different options for resolution, and importantly, do that within the context of the currency and the jurisdiction of the legislation. If you don't know how to find the legislation, have a look at my legal research videos as a quick reminder. In terms of exploring the legal issues, you need to identify those legal issues, make a clear statement as to what they might be, and then when you're referring to legislation or authorities, you do so in accordance with the Australian Guide to Legal Citations. So again, this is all very familiar, isn't it? These are the sorts of things that I was talking about in terms of what a model answer might look like, or an excellent answer might look like in terms of the second assessment. The next one is concise and detailed advice, clearly communicating submissions or options. So you've met the criteria if you provide clear advice, multiple options are identified. And that was Tanya identified that, and Amy Lee. So you've got to provide clarity, and you've got to provide options and clear statements. Clarity and options. The next one is problem solving. This is where you'll really use your toolkit. So you need to consider to some degree problem solving techniques. Think about consciousness of gaps and deficiencies. If you can identify something that is deficient in the question, then so much the better, and make the call. It might be that the deficiency relates to the facts, or it might be a deficiency in relation to the law. But remember, of course, that when you're answering a legal problem, you're called upon to answer a snapshot, which in a real sense would be much more fleshed out. So you might say, in answering this question, I'm making these assumptions, or in answering this question, I'm ignoring these matters that might otherwise be relevant in a different context, or something along those lines. In other words, if you're answering a statutory interpretation problem and the problem happened to relate to criminal law, that's not necessarily a hint. But if it did, you wouldn't necessarily spend a lot of time on dealing with issues that relate to crime and criminal law studies. So you can make that statement and include that provision. And from a presentation perspective, make sure that you have prepared something that is persuasive and that follows the general rules. It's got to look the part. And we're all human. Every recipient of information is going to look at the information and the way in which the material is set out, and to some degree make at least a superficial or preliminary assessment as to whether this is likely to be good. If you present something with different fonts, inconsistent headings, gaps that are obviously shouldn't be there, or information that is scrunched up, then you're just not going to be in a position to persuade as readily as you could if you presented something that looks the part from the outset. So that is helpful. Tim's asked a good question. Can hyperlinks be used in the take-home paper? Yeah, I don't mind if you do. When I say don't use hyperlinks generally in papers, I'm really referring more than anything else to this. Sometimes when people are referring to legislation, we don't get this much now, but when people were referring to legislation, Section 8 of the Civil Liability Act or whatever, they'd give me the hyperlink link to that section. That's not what we do. That's not part of the AGLC. So within the constraints of AGLC generally, I don't mind if you include a hyperlink as an extra something to, it'll help me in assessing the work if I can go straight to it. So you don't have to, but I don't mind if you do. Other unit coordinators may have a different view on that, so be guided by them. All right, so once you've identified the rubric, you've got a good idea of what it is that the examiner is asking you to do, you're in a position to start preparing some notes and working through it. Now this leads me then to the second, to the assessment from last year. If you've got that on the screen, please look at that, and you should also have access to the answers, the answer guide rather. Then there's never really an answer, it's just an answer guide, and that's what I've prepared. Now can I ask, have we all tried to answer this question independently of the answer guide and then gone back to the answer guide to, yeah, so when I refer to the 2017 paper, sorry, I'm referring to last year's paper, which I think was it 2018, term 1, but the one that's on the Moodle site. So hopefully you've all had a look at that. Now I should indicate that the question for this year won't necessarily follow the same format. So if it may be similar or it may be of a different style, but the reason I'm referring you to this is that because you've got the question and an answer guide, it gives you some idea of the thought process that I think is relevant when answering a statutory interpretation principle. And those of you that were thinking laterally probably would have looked at the answer guide in preparing your toolkit. Did anyone do that? Did anyone look at the answer guide and think, all right, that's the way John's thinking of, that's the way he answers a statutory interpretation problem, and I'll use some of that in preparing my toolkit. Did you do that? I don't mind if you did. You don't have to be shy. I made it available for everyone to look at. Okay, if you didn't, that's fine. You may have prepared something that's really good for you. But if you're still struggling and you think, oh, my toolkit doesn't work for me, feel free to look at the answer guide from that paper that I'm referring to, and it might assist you. Okay, so again, if you're watching this as a recorded session, please look at the examination question. I mentioned the facts briefly last week, and it's to do with Work Health and Safety Act. It's to do with an industrial accident, the death of a worker, and issues to do with liability, vicarious liability within a quasi-criminal sense. So the first thing to do, and the first question was, does the Act apply in the current the current factual circumstances, and support your answer? So what you need to do is identify not just the Act, but also the particular part of the Act. So in order to answer that question, does the Act apply in the current factual circumstances, it seems to me that you need to identify the material facts. You need to identify the issues. This is sounding very much like the IRAC method, isn't it? And from that, you can determine the legislation and determine the part of the legislation that applies. Now, the trick here, of course, is that not every section in a piece of legislation comes into effect at the same time. Can anyone tell me, in broad categories, the two different types of sections that might come into effect at a different time to the bulk of the Act? So you've got the bulk of the Act, and there are two broad categories of sections that may come into effect at a later time. Number one, William, amendment. Correct. That's one I had in mind. Gareth thought delegated legislation. That's good thinking. I hadn't actually thought of that. Megan was thinking along the same lines in saying regulations. They're good thoughts, but that wasn't what I had in mind. Again, there's no necessarily right or wrong answer to this. Schedules, maybe. Schedules may come into effect at a later time, but why would they come into effect at a later time if they were not part of an amendment, is really what I'm getting at. All right, so the answer that I'm looking for is this, that upon the introduction of legislation, the process of having the assent for the Act itself might relate to all of the legislation. But it is possible in some circumstances for particular sections of the Act to come into effect at a later time. So that's what I was really looking for. It might be part of the original draft, but it may be that that section comes into effect at a later time. So you need to be mindful of that and have some techniques to determine when that might apply and when it won't apply. So you need to think about that within the question of, does it apply to the current factual circumstances? Number two, this is again the question previously provided. Identify the division that contains certain sections. When did it commence, and support your answer? Okay, so again, this is an amendment, and the parts of the amendment that are introduced may not all necessarily come into effect at the same time. So in the answer guide, I referred to the Acts Interpretation Act, Section 15 of the Queensland legislation, in answering whether sections 34C and 34D were in force at the relevant time. Then firstly, you need to note that the amendments were included in Part 2 of the Act, and that part was inserted by an amendment in 2017. So you need to be able to find the date of assent. You need to have a way of finding where to look for that. You note the heading, Work Health and Safety and Other Legislation Amendment Act, and you need to identify and follow the Legislative History tab in the website. Now, you won't find this necessarily in Austlii. I go to the legislation site for this. So you should be able to find the legislation history, and that will answer that question. Number three, identify the subsection or section you believe prosecutors may rely upon to charge the owner of the business with an offence. Again, you're looking at the section there, which provides for the conduct of, amongst other things, executive officers. So in this instance, it was Section 34A was a critical section, but you'd need to look at sections 31, 32, 33, and then 34A. The particular section also referred to person conducting a business or undertaking. That was defined in Schedule 5 and also Section 5. So you refer to Section 5 and then the schedule as well. Now, what was interesting, it was this Gareth and Megan correctly identified something that is often overlooked, even in practice, and that is the importance of regulations. So in this particular question that I set for students last year, the students should have looked at Regulation 7 of the Work Health and Safety Regulation 2011, and that refers to Sections 5, 6 of the Act and other sections of the Act, so that there are relevant parts of those regulations that will have a bearing on your answer. So you must be able to find the regulation, which is generally part of delegated legislation, probably the most important part of delegated legislation. Then you need to consider the purpose of sections 34C and D. Again, if you're looking at issues to do with purpose, we're always considering things like Project Blue Sky, and we're looking at the second reading speeches and explanatory memorandum, but I'm sure you're all well and truly aware of that now. In the context of this answer and the conduct of a body corporate, you needed to consider Section 244 and Schedule 5. Now you might think, well, this is very random in an Act. How am I supposed to find all these sections? Well, before you look at the Act in detail, we've all been trained, haven't we, to look at the Act broadly to make sure that we check all the pieces of legislation, all the parts of legislation that might be relevant. So in a quick scan of the heading, you're looking for things that might stand out as being relevant to answering a particular problem. And that's where you'd see Section 244 hidden away deep in the Act. Section 20 of the Act deals with the imputing the conduct to body corporates, and it refers to a number of duties, 27 through 29, dealing with the duty of officers, workers and other people at the workplace. So they're all particular importance for this particular case. Now, then we asked you to say, what do prosecutors need to prove to successfully prosecute Tracy Wood, who was the owner of the business? And that really involves looking at the exploration stage. So you're looking at the explanatory notes, you're looking at the individual sections through the Amendment Act, you're trying to ascertain the purpose, and you're then considering other pieces of legislation that might be relevant. In this case, the Act specifically states that Section 23 of the Criminal Code does not apply to an offence under Part 2A, industrial manslaughter. So that goes on to deal with that issue of prosecution and also defence. In the question, I've raised an issue of prosecutorial guidelines. So if you're dealing with a criminal or quasi-criminal matter, then you need to look at that issue of prosecutorial guidelines. Question, was this question based on a real case? Now that wasn't. Quite often I do answer or create a question based on a real case, but this one wasn't. Now, further questions, 12 through to 13. What's interesting in question 15 is that I ask you to change your answer to question 7 depending on the date of the event, if that changes. So you need to be aware of that issue also. Now, that's meant to be a flying run through and an encouragement to you to look very carefully, if you haven't already, at the answer guide that I prepared. Obviously, if you're writing an answer in an assignment, for an assignment or an exam, you couldn't possibly cover everything in the answer guide. And I've got to tell you, that's pretty common. When we write an answer guide, we may well have far more material than you could possibly consider putting into every answer. So part of the skill that you must develop is taking a large amount of material and distilling it down into a word count. And certainly in that case, the answer guide is far beyond. I think it was 4,000 words, so it goes well beyond what you'd actually write. 4,000 words seems a lot to write and research within 24 hours. Yeah, it was, and it is, but when you've got a word count, you won't have 4,000 words for the take-home paper, but when you have a word count, sometimes you'll extract in the first run, where you're essentially, to some degree, cutting and pasting material into a working document. Make sure you have it properly attributed so you know where you source the material. You may have far more words, and then it's a matter of condensing it. It's more of a problem if it's the other way, but it can work both ways. So, but I'm not asking you to answer I'm not asking you to provide a 4,000 word response. Question is, do we need a bibliography or references? Not shown in the guide. No, don't include bibliographies. Don't include an end note of references. If you refer to material and you actually cite material in accordance with the Australian Guide to Legal Citations, that will appear in the footnote reference. So that's where I'd like to see it, and there's no need to include it. In fact, whilst I haven't marked anyone down for including a bibliography, I really don't want you to include it. And the simple answer is it's not part of the Australian Guide to Legal Citations. It's also something that we don't do in practice in law. So each of the professions have their own little ways of doing things or rules. So we are guided by the AGLC. So, and that's, say, in contrast to the Harvard method of footnote referencing that many of you from different disciplines may use when writing assessment work. So don't use that. Use the Australian Guide to Legal Citations. So basically, normal footnote. And yes, for the take-home paper, normal footnote rules apply. Okay, any questions then about the paper that I set last year, the answer guide that I prepared for it, or the comments that I've made this evening around those issues to supplement them? All good? Okay, just to get you thinking about your technique for answering a statutory interpretation problem, I'm going to just refer you now to a textbook which is not prescribed, but still very useful, very well written, and it is Statutory Interpretation Principles, The Laws of Australia by Hersfeld and Prince. So that's what it looks like. The reason I've selected it is that I note that the way in which the paper is set out, or the book is set out, follows to some degree, loosely, the way in which you might answer a statutory interpretation problem. So I'll just go through the chapters, give you an idea of how the authors see it. Chapter number 1 is general principles. So it may be that when you're writing an answer to a statutory interpretation problem, you include some commentary in relation to, general principles. So some of you might start by some reflections on the historical approaches to statutory interpretation. That's what these authors do. My personal approach is not to do that, and you'll note that I was careful not to teach you the historical approaches to statutory interpretation at the start. Many people say, no, you've got to do that at the start. Logically, you start at the beginning and work your way through. My view is, no, you stress the important things at the start and then talk about how we arrived at that by referring to the history at a later time. Just a different approach. And also, under the heading of general principles, the authors refer to the modern approach to statutory interpretation. Again, no surprises here. Subheading 1, context. Subheading 2, use of purpose in the modern approach. And then limits in the modern approach. So if you're jotting these things down, they're the sorts of things that you might want to consider when you're answering a question. Or even just think about, so that you've got this checklist. So that's number 1. Number 2, step number 2, according to this textbook, is meaning of words. So within the context of meaning of words, the authors are asking you to think carefully about some of the approaches that we adopt in law in that regard. So there might be issues to do with technical or trade meanings. So if you haven't included that in your guide, you might want to do so. Issues around non-legal technical meanings. Then, as many of you did in your toolkit, you talked about things like means and includes, shall and may, shall, must and may, those sorts of things, plural and singular, and a lot of this is from the Acts Interpretation Act. But again, that's the way in which these authors saw the approach, that step number 2 is to consider the meaning of words within the context of those various subheadings. Number 3, they say, is construction as a whole. Now, again, this is not, the reason I haven't taught you from this text is this is not the approach I use, but I'm mentioning it as a different approach that you might find appeals to your sense of logic. So number 3, construction as a whole, deals with issues of looking at the introduction, the short title, the headings, marginal notes, schedules, and then thinking about some of the linguistic canons of construction. So general and specific provisions, for example. Number 4, the textbook writers number as presumptions. Again, it's not the order I would do it in, but there's nothing wrong with this at all. And if you think it's the right approach, that's great. So presumptions, again, we think about common law presumptions. We think about presumptions of territorial application, presumptions concerning the Crown, and of course, the very important one when we think about presumptions against retrospectivity. So, and another one, which crops up a lot, is presumption against permitting a person to benefit or take advantage of their own wrong. So these are all, if you like, common law presumptions, and that's what the authors in this instance said was step number 4. Number 5, and I'm using this loosely, these are really their chapter headings, but I'm following their logic. Number 5 is precedent and interpretation, and number 6 is extrinsic materials, and then number 7 is looking at amendments or repeals and dealing with the commencement and duration of acts. So I would have actually put that as number 1. But these are different approaches that you can use. All right, I know I've been doing a lot of talking. Are there any questions generally or specifically? All good? Okay. And Tuna was asking about the criminal code in the case of that industrial workplace. I'd have to have another look at it. As I recall, section 23 doesn't apply, but beyond that, yes, I think it would apply. Okay, well, that might wrap us up for this evening. I know it's a short session. So we will next week deal with any issues. And I think I released the paper on Thursday. Is that correct? Thursday? All right, good. So we've got next week to do a final overview, and there will be a lecture next week. It'll be unstructured. It's mostly questions. Sometimes the last lecture is very long, sometimes really short. So to some degree, it will be driven by you. All right. Well, thank you very much for your attendance this evening. We'll see you next week, and all the best as you prepare in a practical sense for your examination. All the best then. Bye.